right, let's see. We hit the buttons, we did the stuff. Let's see if YouTube's gonna work right today. It looks like we're connecting okay. All right, let's see. Yep, looks like we're good. All right, cool. So a lot of stuff to kind of go over. It's been interesting, and happy Friday, by the way. By the time we get into it, I forget to do that sometimes. So happy Friday. Hope you guys are ready for the weekend. And hopefully you kicked some butt this week, got a bunch of stuff done, and your to-do list is basically knocked out, and you can enjoy the weekend and have some fun. We have my friend and I, we have a pickleball tournament this weekend, so we'll see how that goes. That should be fun. So, all right. So it's interesting because they haven't had a lot of updates on the Pacer website. There's been a lot of updates of like moving lawyers and stuff around, so this could kind of be an indication that a lot of stuff is happening behind the scenes, excuse me, as they're making some adjustments and doing some stuff. So lawyers are coming in, lawyers are going out, they're like switching up the roster. So that usually means some stuff is switching. About 2 weeks ago, they had the in-person meetings in the courtroom on the 1st and the 2nd, so it could be some updates from some of that stuff. We got 2 more things that dropped this week, and we'll kind of go through that. And this can also kind of be, a lot of times maybe there's negotiations happening behind the scenes that we don't get a chance to see. So when you look at like what happened with Michael Churanowski and how he filed to be dismissed, and then WFG dismissed it. Sometimes what can be happening is they do an agreement behind the scenes and just say, hey, if you promise not to sue us, we'll promise to stop suing you, and we'll just kind of let this go, and they do some kind of agreement behind the scenes that doesn't get into the court documents that we can't see. So who knows, there could be some stuff happening like that. And don't forget, you can find everything over on Locals. So McKenzieLong.locals.com. If you want any of the reports or any of that stuff, you can go over there. All of this stuff is here for you. You can click on content. All of the videos and everything's in there in the news feed. And so you can find all of that stuff. Oh, hey, Jimmy Ross, perfect. I wanted to actually talk to you. You PM'd me on Facebook. Cool. Yeah, I apologize. I didn't mean to do this. I don't delete any kind of messages. And I got your messages here on YouTube, but when I click on them, it disappears. So Jimmy Ross, I apologize about that. I don't know if you deleted them or YouTube deleted your comments. I can see them here in the thread, but I can't see them anywhere else. So I apologize for that. I wasn't able to respond to them because when I click on it to respond, it's just gone. So anyway, thank you for PMing me on Facebook, and we'll talk about that as a former Pinnacle guy. I would love to hear some of your stuff on that. And we'll talk a little bit about that as well. So don't forget to go over to Locals. You can find all of that stuff. You can download everything over there. Oh, and don't forget to, on YouTube, make sure you subscribe and do the bell, because we are still being demonetized. YouTube has taken all of our stuff off the platform. They're not promoting anything. So our viewership has totally dropped. You can see they're behind the scenes messing with stuff. Some videos will do well, other ones won't, depending on what's said in them. So there's a lot of censorship stuff that's going on in there. So if you don't hit the little bell, and I think you have to be subscribed to have the bell. If you don't click the bell, you're probably not going to get updates on stuff. So make sure you're there. Make sure you're over on Locals if you want updates on these things. Okay, so we're going to talk about 3 different things. I want to do some comments. There were a couple comments that are a common theme that people keep saying, so I'm hoping maybe if I address them, then maybe we can stop having the same exact conversation over and over again. The second is the discovery letter from Eric Olson. We'll go through that. They are still not getting discovery. So it's been what, like over a month now? And Olson is still not turning that stuff over. We'll get a chance to see why he's not turning it over. Some of it is redacted now, so they're getting into where they'll actually black things out that we can't see them, that only the court can see, which is kind of interesting as well. And then the last thing that we'll go over, number 3, is going to be Cofield's motion to dismiss. So he's trying to get out of the case as well as far as the First Amendment stuff goes. So lots of stuff to go over here. I'll try not to go into super detail because it feels like it's kind of a copy from Olson's. They basically use the 16600 to blanket out everything that they've done wrong. So maybe we'll do a drinking game around that if you guys want to take shots every time you see 16600. So maybe we can stop after 15 of them, and then 2 pages in we can get a good understanding of at least what they're trying to say. So all right, so let's do this first one, or first 2. because I keep getting these, and maybe this will help out. So maybe if I can move this over here. So Manny wrote, can I open this thing up? Yeah, here we go. All right, so on the last video, we talked about the difference between Levitan and Olson. And Manny, and he doesn't have a real user name or anything on here, but when you click on his profile, it says Manny. So I don't know if anybody knows who this is, but he's talking about basically the whole stuff with Jeff, right? And little do you know, Jeff is a partner with Vantage. I think we actually talked about this, so I'm assuming Manny didn't even watch the video, right? Because I think we found out that he was, Jeff is an executive over at Vantage, and he received the offer shortly a while back and told Beauvais to be the face of Vantage. This guy, Manny, had a fallout with them. Project being part of the Superbase team, Jeff wanted Cap to be a part of Vantage. He declined to do so because of personal issues. It's sad that you really don't know what's going on. I think we covered all of that. Why do you think Jeff transferred his code to his wife? Ever since WFG asked him to show, I don't know anything about that. Receipts for All for One, Jeff refused. It's been a fallout with WFG and Jeff. Okay. You haven't seen All for One at the convention. Jeff hasn't. Well, yeah, he's not with the company anymore. So, of course, he's not going to speak there. Jeff is playing chess. Well, y'all are trying to play checkers. Beauvais left and took his whole hierarchy. So here's where it gets interesting for me is that, and then people get so emotional about this stuff, right? And I understand, I've lost teams. I know how that goes. But if Beauvais did something, that's not a reflection on Jeff if Jeff is outside of his contract, right? Like if Jeff sat out the 2 years, then he's no longer under the contract that he had with WFG. He can then go back and recruit people from WFG if he wants to. I'm not saying he should. I'm not saying that I like it. I'm not saying that you have to like it, but that's just how the contract works. And that's the whole point with the Olson stuff is why didn't he just wait the 2 years and then he could do whatever the hell he wanted to do, or do it outside of the 50-mile radius and he can literally do whatever he wants to do with the other 90% of his team or whatever it is that's outside of California within 50 miles. But he didn't do that, and that's kind of the point. And I understand it, like people get emotional about this stuff, but that doesn't change the laws. And unfortunately, I don't know if it's just, it doesn't seem to be just WFG, because we're doing a lot of this stuff in the legal system over the last 10 years, that if you just don't like a specific political candidate, if you don't like them, then you change the laws to fit whatever you want them to be guilty of. And it doesn't really work that way. Like, you got to find guilt first, whether or not you like the person. So Jeff, being outside of the 2 years, it doesn't matter what he does. He could literally show up to a WFG event if he wanted to, stand out front and recruit people at the door of the next convention at Mandalay Bay or wherever they're holding it. He could legally do that, and there would be nothing that WFG could do about it. Now, I don't think that he would, but he's outside of his contract, so it doesn't matter anymore. So if you want to get into the topic of what Beauvais did, if he did something like that and breached his contract, that's a different conversation than what Jeff did, than what Levitan did. So I don't understand why people can't separate those two. Like, once you reach that 2-year point, you're basically free to do what you want to do. That's it. So now if you want to talk about other people, that's fine, but that wasn't anything about what was going on with Vantage. I don't know much about what's going on with Vantage. So he was saying that if you want to ask him about real news, you can, which is fine. I checked his YouTube profile, and he doesn't have any videos or anything there, so I don't know how you would get that information from him. But anyway, so I don't know. If you got stuff, Manny, send it to me. I don't know what else to do to help with any of that. And then he had another video, or another one, which I thought was interesting. And sorry to go through this, but I get these like all day long. Did he do this one, which I think is hilarious, right? Because he goes, stealing, how is it stealing? Maybe you should be a better leader to your people. Then they would think twice about leaving you. Stealing, when did people become property or an item? We are not in high school. People are grown adults, which they have made their own decision. You sound foolish. I agree with that. Your spouse also isn't your property, right? You go into an agreement, is a great analogy. So you're married, you marry your wife or your spouse, you go into a contract saying that you're not going to cheat on each other, you're going to be faithful, you're going to stay with that person for the rest of your life. They're a grown adult. But if your friend comes in and entices your wife to leave you, you would probably say that they're stealing that person, right? They're not your property, you're not a slave owner, but it's still, you still wouldn't look favorably upon it. And then you add in the other aspects of it, of were they lying about you? Was your friend going, hey, I saw your husband out with Becky and there's probably something going on there, and so they're using deceptive tactics to sleep with your wife, well, then you would say they stole that person. So I understand becoming a better leader, but that's not exactly what happened. What happened was Olson was lying about what was happening in WFG. He was saying certain people were going. He was saying that the company was basically falling apart. Some of it had some truth to it, but a lot of it was not true. So that's why people consider it stealing, was because he wasn't doing it in an honest way. If he had done what Jeff did and he sat out for 2 years and then went back and recruited everybody he wanted to in WFG, there's literally nothing that WFG could do about it. So can we stop having these same exact conversations? The challenge is these people never watch the video anyway, so I guess it doesn't matter, but I wanted to at least address those, that very, very different situations than what Olson is doing, where he purposefully comes in, doesn't wait out his contract, goes against the contract in the non-solicitation, the non-disparagement, and the confidential information, two entirely different situations. But people can't seem to get a grasp on that because they are emotional about it, or they want something to be true, and unfortunately that's just not how the law works, right? You can't just change the law because you don't like a particular person or the way that they've done something. They either broke the contract or they didn't break the contract. It really boils down to that. So anyway, sorry to have to rehash these things, but it drives me nuts. So anyway, all right, let's get into the next one. This is going to be Olson's filing of basically why they have not turned over the information that WFG keeps asking for. They haven't turned over the discovery information, and so we're going to find out why they haven't turned over that information so that maybe we can get a better understanding. Now, to me, this all seems like a huge delay tactic. They're just trying to wait it out till they can get to the dismissal part and then say, well, look, WFG doesn't have any proof, so I guess we just need to dismiss this, but let's go through it. So basically they're saying that we read the previous one that WFG had filed on May 10th, and so they're basically responding to that. They're saying that it lacks substantial justification on the part of a larger pattern of misusing the expedited discovery process. The subject of WFG's letter is governed by the proceeds of the protective order. So remember, previously they were waiting to turn over information because they didn't have the protective order. Now they have the protective order, and now they're saying we don't have to turn over the information because we have the protective order. So, which provides that if a party objects, both sides will meet and confer within 14 days. So exactly what we were talking about before, this all just seems like a big delay tactic that they don't want to give up the information. And if the parties are unable to reach an agreement, the designated party has 21 days to file a motion. So again, we're going to delay for 2 more weeks so we can do a meet and confer. And then the designated party has 21 more days to file to maintain the designation. The WFG filed its letter without meeting or conferring following any of the following procedures of the protective order, and its underlying objection to the AEO designations is meritless. If anything, the WFG letter only demonstrates that it's trying to use the expedited discovery process for reasons beyond the limited purposes allowed by the judge. This is to support a supposed motion of preliminary injunction. At the time, WFG has withheld its production and unilaterally canceled its depositions of its own witnesses. All this is the same conduct the court admonished. WFG is in its order denying WFG's first motion to compel, which is stated, no fees or costs are rewarded. So WFG's efforts to prevent its former agents, Eric and Sandra, from compelling against it. Court denied the motion of a temporary restraining order finding that the non-solicitation language is trying to reinforce the valid 16600. So this is why this becomes a bad thing for the industry. And right, we can get outside of whether we want our team to win if you're on WFG side or if you're on GFI side. The reason why this becomes a bad thing for the entire industry is that if we're going to apply this 16600, all you have to do is be in California and all of your contract is completely void. Meaning that you work for a company, whether it's Vantage, whether it's GFI, whatever, that has a non-solicitation clause, that has a non-disparagement clause, that has anything about confidential information, all you have to do is move to California and you're allowed to do whatever you want to do. This is bad for the industry because it means you can do all of these things that GFI has been doing to WFG in the anchor leg strategy. It means that you can show up at their events inside of your contract date and recruit people over. You can have people do stuff like what Levi Mavoni has been doing, where he's been pretending to be a WFG agent for the last 4 or 5 months. He's showing up to WFG events. He's shaking everybody's hand. He's pretending to be your friend. And then he's recruiting your people out from underneath you at these group events that you've come together and agreed, hey, we're going to bring them together so we can train these people, not so we can recruit other people's people. And all of that, if we're going to uphold this and say that the 16600 is valid, and it should negate every single everything that's in the contract for these insurance carriers, then basically it's going to become the wild, wild west. It means that we're allowed to do whatever we want to do whenever we want to do it, simply because it falls into a non-compete category, meaning I can't do my business unless I can recruit other people from somebody else. Well, then, okay, it's a lot of what we're seeing happen in the world today around former presidents, that we're trying to change the laws and the rules to fit one particular person. And while it might fit the needs of today, what happens is we destroy everything after that. Because then all we have to do is say, well, what they do is they go back and they look at the court cases. And so let's say Eric wins, the court case gets filed, Eric wins because of the 16600. Then all the next person has to do, so when Matthew Welsh decides to completely take everybody that he's trained from GFI and start his own company, all he has to do is point to that previous lawsuit and say, see, in this particular case, they said it was okay. So now I'm out and I can do whatever I want to do because they were allowed to do whatever they want to do. So you can see this spiraling of a downward cycle of what happens to an industry because we make one exception along the way and that snowballs into other exceptions. And we're seeing that happen with a former president right now, where there's literally lawsuits that are happening, and they're trying to fit the law. They're bending the law in a way that kind of eclipses what he's done, and then we're going to go after this person because they don't like him. Then the challenge is the next time that there's a president that somebody doesn't like, we can then apply those same laws. So it's the erosion of our political system because we want to make exceptions for today instead of applying the rules across the board equally for everybody. So anyway, kind of a rant there, I apologize, but you can just see this downward spiral of society because we want to keep making exceptions for everybody. WFG's subsequent admitted it knew it had no merit when they were filing for the TRO, the temporary restraining order. The court allowed limited expedited discovery. WFG propounded overboard requests, refusing to enter into a protective order without a one-way carve-out in its favor. So basically what they're claiming here is that WFG wouldn't just roll over. We wanted to give them, I shouldn't say we, Olson's team wanted to give them only the information after the termination. But everything that happened with the form of GFI happened before his termination, before he got caught doing the anchor leg strategy and moving everybody over, and people started reporting him for recruiting agents from WFG to GFI while he was still inside of WFG. So they only want to give out certain information, and they're saying, well, because WFG isn't just going to roll over and only accept the information that we want to give them, Well, then they're asking for special exceptions, and the court affirmed to deny in full because the request was overbroad. Non-protective order was in place. So they've now put the protective order in place. They've also shortened or limited what they were asking for. So they've met these two qualifications, but GFI is still trying to say that they're still going back and reminding the judge, right? It's kind of like, remember that when you get in an argument with somebody, remember that time you told me this and then you didn't do it, and right, like they're trying to like remind the judge of these things that were happening. And they're talking about how they filed a motion in the midst of a meet and confer process, because WFG is trying to get this stuff going, right? So it's kind of like when you follow up with your client and you're supposed to meet on Friday, and then you call them on Friday and you're like getting things going, but the client is really kind of just stalling, and then they get mad at you for following up with them. I don't know if anybody's ever had that happen or if it's just me, but that's basically what's going on here. They're like, look, these guys keep bugging us. They keep asking for information. They keep trying to move the ball forward, and we don't want them to. So this is annoying to us, and judge, we wish that you would do something about it. After refusing to agree to a protective order for more than 20 days, WFG finally agreed to it. It's like, okay, so they agreed to the protective order, immediately produced 12,587 documents. The challenge was all of these documents were after the termination. So it's literally nothing that WFG wants. And so they're playing the game of, we gave you all of these documents. It wasn't the over 100,000 that we had found, but we gave you, I don't know, 10% of those. So why can't you just be happy with that when it doesn't even fall inside of the designation of what they wanted? They want the stuff from November to the termination date in January, and they turned over stuff from after January, which doesn't really fall into the category of anything that WFG needs. WFG sent a letter challenging the Olson's designation of 978 documents as highly confidential. The letter stated that unless Olson's agreed to designate all 978 documents by Saturday, would seek immediate relief in the court. And again, so like WFG is just trying to move the ball forward, and they keep delaying it. And now they're going back to the judge and saying, look, they're just hounding us. They keep trying to move the ball forward, and we don't want to move the ball forward. The parties meet in a meet and confer, discuss discovery issues like WFG's failure to produce anything beyond 157 documents already in the Olson's possession, but WFG refused to say when the Olsons can expect the next production. On call, WFG demanded that and it's redacted, we can't see what's there. The Olsons told WFG that they would review the material, but intended to adhere to the procedures of the protective order. WFG then sent a joint letter on May 10th and demanded Olson's respond within 7 hours, or else WFG would file unilaterally. After the Olsons explained that this approach was contrary to the court's rules in the protective order, WFG has negotiated for weeks. WFG filed its unilateral brief on Friday night. Olson's highly confidential designations are appropriate. So this is where it gets kind of interesting too, because highly confidential, basically every time you see this, what they're trying to say here is this is the people who have gone to WFG or have gone to GFI. So they're trying to keep a lot of that information as highly confidential, meaning it can't actually be reported or used. Maybe the lawyers can see it, but maybe WFG cannot see it. There's different designations on who's able to see this actual information. And what they're trying to do is protect those agents that have gone over to GFI and are now, like Levi Maboni, are still with WFG and recruiting people out from underneath these events. So if they have this information, WFG would then know whose spouses are over at GFI right now, and they're still acting as spies, pulling people over to GFI. So of course they don't really want to turn over that kind of information. So as a court issue, this case, which the Olsons intended to raise their motion of preliminary injunction, is that WFG retaliated against its workers and tried to restrain their mobility with the unlawful restrictive covenant. So here we go again, in that if you have a agent agreement, it is if 16600 is valid and it negates any kind of agent agreement, then every agent agreement is a unlawful restrictive covenant. So if we're going to say that that's okay, then that means everybody has to be broken from their contract, and um, there's no agreement between anybody inside of the company. So that means you would then have to be afraid of going to any kind of large event because people could do whatever they wanted to do. That when you showed up to convention, when you showed up to training events, you constantly have to be worried about your people being taken because there's no longer a covenant between the people inside of the company. So that means it's free game for everybody. And I don't think that's a good way to go for the industry. Part of the reason why these companies are so successful is it's kind of like a household, right? You and your spouse, if you can create an agreement that it's you two versus the world, well, then it's a pretty safe place to be. But when you have to go out and fight the world and then come home and fight at home, that's a terrible place to live. And that's what we're trying to create here, is that if it's an unlawful restrictive covenant, it means that not only do you have to fight the world, but you also have to fight inside of your own company. And if that's the world that y'all want to create, then that's fine. I wouldn't recommend it. I just don't see this being a good thing in the long run if that's what we want to create. In the negotiations over the protective order, Olson's explained that the reason they were insisting upon the protective order was to protect against this from occurring. So what they're saying is here, we don't want WFG going back and quote unquote retaliating against all of the people who are either still with WFG and with GFI, or that had broken the contract previously in the creation of GFI. So by not turning over or by keeping this highly confidential information, it restricts what WFG can do with this information or who can see it. And that doesn't allow them to go after the people that need to be gone after. It would kind of be like if you were a mob boss and you're like, hey, I'll tell you everybody who's in the mob, but you can't sue them after that. Is that okay? I'll tell you their names, but you can't legally do anything to them. Would that be all right? Well, it's like, no, then what's the point of having the names if we can't do anything about it? You're going to tell us all the names and every crime that they've committed, but you're going to also protect them at the same time, saying that we can't do anything about it. So what's the point of having the names and knowing the crimes if we can't pursue anything with it? So you can see how they're kind of playing games with the information of what they're trying to get. And they're saying, well, we're protecting our agents. We don't want WFG to go after these people for that unlawful restrictive covenant that said that we were going to cohabitate and we were going to work together and we were going to be a family. We don't like that. And so if they're going to go after these people, well, then we don't want to give you the information, or we'll give you the information, but you can't go after them. So it's kind of like it doesn't really matter either way if this goes through and they're able to do that. Highly confidential documents at issue constitute such materials, meaning that it's names and numbers and people who are currently over at GFI and potentially still working with WFG. Their designation in no way interferes with WFG's ability to seek a preliminary injunction. In seeking expedited, WFG starkly admitted in a letter to the Olsons that it wanted to use them for ulterior purposes to investigate the unlawful behavior of its own current agents and concealing the ongoing use of the anchor-leg strategy. Exactly. So WFG wants these names and numbers and understanding who these agents are so that they can investigate the unlawful behavior of those agents and who are still being concealed and who are still using the anchor-leg strategy and decide whether to enforce their covenant against former agents. Exactly. That's like the whole reason why the people would want the information. That's why, if you're looking at a mob, the reason why you want those people named in the lawsuit is so that you can also go after them. It just makes common sense. And so they're saying, well, we're not going to give you the information if you are going to go after them. Then what's the point of the information? You might as well just keep it. The protective order expressly permits parties to designate documents as highly confidential, where disclosure could create a substantial risk of serious harm that could not be avoided by less restrictive means. WFG's retaliation via the enforcement of illegal covenants. See how they, like, words are so important, Because if you just take out this one word, it all makes perfect sense. WFG's retaliation via the enforcement of covenants makes sense? Like, of course. So they want to apply the rules equally to everybody. But because GFI is saying that it's illegal covenants, well, then we go, oh, okay, well, that makes sense. So are they illegal or are they not illegal? That's what all of this is coming down to, is that 16600. And if we're going to find that that's legal, then I have serious concerns for the industry moving forward, at least in California. But you know that's going to spread everywhere else, because they're going to go, well, they found in California that this happened, and I live right next door in Nevada, so why wouldn't it apply here too? The communications WFG claims it must ultimately provide its client list, right? This is also for clients as well, because they're looking for churning too. Did the agents come over? Did they churn? So if you recruited an agent from WFG and you had a Transamerica policy with them or nationwide policy, and they move over to GFI, did you replace that policy? These clients that you're moving over, did you replace those policies? The only way they would know is if they get this list. And so this is all redacted. We can't see what's in here. But yeah, of course they would want that information. We want to know, did you break the law? And GFI is basically saying, well, we won't tell you if we broke the law if you're going to use it against us or against them. So it's like, okay, then what's the point of having the information? Anyway, WFG also misapprehends expedited discovery. The process is supposed to be limited and fast. Okay, who is? In the beginning, you're mad that WFG is moving fast. And now you're saying that they misunderstand it because it's supposed to be fast. The Olsons propounded discovery on March 6th and have not received a fair response. At that same time, they quickly produced over those 12,000 documents that were nothing that WFG wanted. They were all the documents outside of being terminated, which have nothing to do with anything, as soon as the protective order was entered. Insisting of engaging in expedited discovery in good faith, WFG is using its superior resources to subvert the process of the protective order and fight about designations, while using the pendency of its litigation to intimidate its workforce. Its unilateral letter brief should be denied. So what they're saying is that I guess it's kind of just repeating what we've already talked about, in that they want to use this litigation, which is fair, right? You do have to watch out for this, because if you look at what's going on with the former president right now, the challenge that they have is that the government has unlimited resources. So all they really have to do, whether they win or not, is just tie you up in court until you run out of money, because the government never runs out of money. So you do have to be cautious of this. Obviously, Aegon, WFG has more resources than Olson does, but I think this particular claim about WFG purely doing that, and I guess this falls back to that same question, right? Is the 16600 a coverall for everything? Because if that's true, then Olson hasn't done anything wrong, and WFG is doing this just to punish Eric Olson, which becomes the next problem we have, is that even if the contract's no good, then anybody who breaks it therefore can't be sued for it, because they didn't break any contract, right? So it would mean that anytime that a company tried to do something against you, they're using their superiority and their power to go against you, which is something we do have to watch for. This is important to pay attention to, but I don't see it applying to this case. And that's what we were talking about with Levitan and Olson. Are they specifically targeting Olson for no reason? Are they specifically targeting GFI agents for no reason? And that's kind of where it all boils down to. So they submitted this on the 13th. Anyway, I got a little worked up there. But I just think this is so stupid. And I think it's terrible for our industry long run if this goes through. So that's where we're at. They're saying, hey, you should be happy with the 12,000 documents that we turned over that are meaningless to you. And you should be happy that if we turn over these other people who are still part of GFI and WFG, that you can't do anything about it. And if you're not happy with that, then we're just going to keep delaying this entire process. Which, for Olson's side, that is fair, right? Like, of course, you're going to fight that and the best that you can. But this kind of becomes a problem where the judge is going to have to step in and do something about it. So anyway, that's where we're at with that. So then let's look at, let me go back over here. Bam, tag that. All right. Cool. So now let's go into Cofield's motion to dismiss on the First Amendment. And we're going to kind of breeze through this. We got to get through this pretty quick, but I want you guys to kind of see how all of this starts to spiral. Because if Olson's able to make the claim that the 16600 is no longer is valid, and so all agent contracts are not valid, then we have this snowballing effect that anytime that your friend comes in and takes your, like, you could literally put on an event with somebody that you like in the business, in the company, in the industry. You could go to that event. Maybe you get called in because you have a doctor's appointment or grandma gets sick or whatever. So you don't show up to that event. That person then takes all of your people that are there, and there's literally nothing you can do about it. And that's how it's going to spiral from here, is that if it's okay for Olson to do it, well, now it's okay for Cofield to do it as well. And whoever else decides to do it, it's going to be perfectly fine for them to do as well. So we're going to kind of run through this. Nice table of contents. Again, this is all in locals if you want to see the whole thing and go through it in its entirety. We're going to breeze through it pretty fast here. Lots of other cases that they're going to pertain to. Again, we're going to talk a lot about this 16600. You've probably like 15 shots in already, so hopefully you're pretty sauced up. But anyway, let's get into it. The introduction. So basically what they're saying is that WFG is trying to enforce a non-solicitation agreement. There is no non-solicitation agreement in WFG. There's no non-solicitation agreement in GFI. They're both called sorry, I apologize. Let me reword that. It's not a non-compete, it's a non-solicitation agreement, right? Very, very different. So both of them have non-solicitation agreements, which is interesting too, because how do you go to court and say non-solicitation agreements shouldn't be allowed, but then you have them in your own company that you just built like 5 months ago? I don't understand how that works, but they're saying that it's deemed void by this court. We've heard a lot about Edwards. A little bit different scenario. Apparently that was an employee and employer. As a result of the prior ruling of this court, non-solicitation prohibition is essential part of restraint of trade of the plaintiff's employment agreement. By naming additional individuals whom the plaintiff is attempting to target, plaintiff is merely seeking to intimidate its current prior workers by quashing competition in California altogether. As a result of its unenforceable void restraint, plaintiff cannot maintain any cause of action in its First Amendment complaint. So again, if we're going to apply the 16600, then whatever you want to do goes. Whoever you want to solicit, whoever you want to churn, whatever it might be, you can go badmouth the company all you want, as long as you're doing it in the pursuit of doing business, which is basically what everybody does, then all of this becomes okay. So if Olson can do it, then Cofield is now saying, well, I can do it too. So literally anybody who goes on soliciting other people's people, disparaging the company, taking confidential information in the pursuit of doing those other two things, you're just allowed to do it, because they should not have any type of non-solicitation agreement in the industry whatsoever. Because if it's not good for WFG, it's not good for the rest of the industry. Cofield began working with WFG selling insurance, and pursuant to the employment contract, watch how they do these words, right? Very important, because they're trying to tie this into Edwards. And Edwards was about somebody who was employed at Arthur Andersen. So if they use these words, it looks more enticing to the judge to find in their favor, we are not employees, but they use employment contract to help it fit into Edwards. So it's all in how you word things that make a big difference. Mr. Cofield was an independent contractor, exactly, he's not an employee, who was promised the opportunity to impact the financial market in hopes that operation of his financial services business. As a result, Mr. Cofield began his career with WFG. Mr. Cofield immediately excelled in his position and therefore made a name for himself through his talents as an independent contractor. For years, Cofield worked with the plaintiff as he made the company thousands of dollars and never reaping the promise of owning his own financial services business he was promised. Which is weird because do you see how in the same breath people vilify Levitan and want him to be prosecuted, but then also want Olson to go without any consequences? And it's weird to me, right? Because Levitan and all the people who have gone Levitan's route are proof that you own your financial business, that at a point you can turn it over to somebody else, you can live off of the profits. So there's living evidence that it actually works, and now he's saying that it doesn't work. And part of this is WFG's fault for canceling the Heritage program. I don't know why they did that. I think they made a big mistake with that. I think that has hurt them more than it has helped them. But in reliance of his independent contractor contract, Mr. Cofield built a hierarchy of which he recruited, trained, and managed other individuals, whom resulted in the plaintiff's prosperity. I'd say mutual prosperity. You could go somewhere else and recruit the same amount go to, I don't know, Amway or something, and you can make, I don't know, $1,000 a month or so, whatever it is. A little bit different. I think it's a mutual agreement, right? That's why we have a contract, because it's a mutual agreement. On or about February 15th, the plaintiff filed a First Amendment complaint naming Cofield and other colleagues once he left the plaintiff's company. Mr. Cofield seeks to dismiss this. They're basically saying that the enforcement of a non-solicitation agreement voids the respect of an agreement between the Cofield and the plaintiff under the 6600. So again, if we're going to apply this, then every single person in every single insurance company who has a non-solicitation agreement is now void, and you can solicit whoever you want, whenever you want. Because they're trying to relate it to a non-compete, and this goes back up to the Edwards and some of the other ones that they use. Non-competes are illegal. I don't know if you've seen that in the news, which I agree with. I don't think that because you leave a company doesn't mean you should never be able to sell insurance again, obviously. But it also doesn't mean in the non-solicitation that you should be able to go back and take agents and clients from a former company. While structured as a confidentiality provision to the agreement, precludes Mr. Cofield from making any statements to anyone at any time regarding of whether it is the truth, which I disagree with. A non-disparaging comment, if it's true, is it still non-disparagement? I mean, I guess you could make that case, but they're going they talk about WFG being overbroad, and then they are extremely overbroad. Because I guess you could make that complaint. Well, if I say anything like our company's better, is that disparagement against WFG? I think most people in a court of law would say no. But if you want to apply it to the umpth degree, then I guess you could make that apply somehow. Structured as a non-disparagement provision, fails to target speech, but instead prohibits Mr. Cofield from doing that which will cause damage to the plaintiff's business. In fact, there is no evidence that identify what confidential information Mr. Cofield made anybody prohibited by the plaintiff's unenforceable agreement. So again, they're just going back and saying that this isn't specific enough when everybody went, which is weird because we just read that the Olsons know exactly what confidential information is, and that's why they labeled it as such. But here, they can't seem to find out what confidential information is. It's just too broad, and so then it should be unenforceable in this agreement. In addition, defendant's First Amendment complaint relies on the cause of action preempted by another law that must be dismissed. Furthermore, the First Amendment complaint fails to state a cause of action relying wholly on its breach of contract allegation, which was deemed void. Plaintiff's claims for tortious interference completely lack identifiable independently wrong conduct, which fails to identify any underlying tort. So again, if we're going to apply 16600, then even the breach of contract for the breach of contract at any point, then if that's void, if the contract's void, then you can do all of these things. There's no such thing as tortious interference. There's no such thing as civil conspiracy if you're not breaking the law. Like, you can't have civil conspiracy to not break the law, right? Like, that would just be a normal act of living. So again, if that 16600 applies, no contract was broken, so therefore we should be able to do whatever it is that we want to do. And if that one fails, all of the other claims behind it fail. The civil conspiracy fails, the tortious interference fails, because if you're allowed to do the act, then doing the act no longer breaks any of the laws or contracts, right? And so they're taking two things. There's the breaking of the contract, which then leads into actually breaking of the law. But if you didn't break the contract, it's hard to say that you then also broke the law, right? Because if you're allowed to go solicit anybody that you want, how then can you conspire to go solicit people if you're allowed to do that? So it's the domino effect. If we apply this 16600, everything else collapses underneath it, and everybody is allowed to do whatever it is that they want to do, and we go back to the wild, wild west. So as a result of the aforementioned, plaintiff has not maintained a single cause of action against Mr. Cofield, and his First Amendment complaint must be dismissed. So if 16600 applies, there's not a single cause of action. He didn't do anything wrong if the 16600 applies. So let's go a little bit into Cofield's background. Mr. Cofield began his employment in 2014 in excess of $200,000 annually. Despite the promise of owning his own business, Cofield maintained his role as a plaintiff enduring numerous hours of work for which the profit of the plaintiff. I don't know. This is the stuff that bothers me, because he's admitting right here that he's making $200,000 a year, which is I don't know, in the top. I don't know if it's quite 1%, maybe it's 3% of the country. Probably definitely in the top 1% of the world. And they have to constantly go back and reference that the company that they work for also makes money, right? So, fueled with the promise of business ownership, Mr. Cofield strived for success, which he ultimately attained while working for the plaintiff. In doing so, Mr. Cofield met multiple people and made lifelong friendships along the way. From the very beginning, Mr. Cofield was under the impression that his own business ownership was for a foreseeable realization through his numerous hours worked and networking ability. As a result, Mr. Cofield attained a large book of clients and supports of his success. And this is part of the challenge that's WFG's fault, right? Because we've been seeing a lot of what happened with the whole Joanna thing. The reason why he was attacking Joanna was because he was trying to recruit people from Joanna's business, which is funny because he's blaming WFG for not doing what it's supposed to do, while he's literally trying to steal Joanna's people to move them over, which would do exactly what he's claiming WFG would do, right? He's saying WFG didn't pay her after her spouse left, but then he's literally trying to take those people that would impact her, the amount of money that she would make. So it's just weird to me that they play both sides of the fence all the time. But WFG allowed it, right? WFG allowed Pinnacle to come in and steal people's people and didn't do anything about it for a long time. And now that it's happening to them, and now it's a problem. It should have been handled a long time ago. As a result of several policy changes, members of the plaintiff's hierarchy began to leave the company. As such, right? So he goes back to the plaintiff's hierarchy. He's talking about Olson here, right? Olson and those guys who left. Began to resonate, was influential members spoke up about the plaintiff. In response, the plaintiff was quick to squash any resistance, resulting in further backlash by the existence of former agents. Despite making millions to plaintiff's business and the failed promise of owning his business, on January 20th, Mr. Cofield was terminated his relationship with the plaintiff. So he resigned, and on the date, the plaintiff responded confirming his resignation. I should have just kept reading. So again, it goes back to, well, I was talking to Olson, and Olson told me these things about the company, and so then I also left. On February 29th, the plaintiff filed a First Amendment complaint, ongoing battle against the Olsons, naming close friends and colleagues, including Mr. Olson or Mr. Cofield. Ironically, this was done after Olsons filed their initial motion to dismiss. on or about February 15th, making nominal changes to its individual complaint. Mr. Cofield was subsequently served the process forcing him into the plaintiff's frivolous dispute. Frivolous. So they did absolutely nothing wrong. WFG is just after them for no reason. The frivolous dispute. To survive a motion to dismiss, the complaint must contain sufficient factual matter. To state a claim to relief that is plausible on its face, they're going to go into a bunch of court filings. Again, basically all this is doing is taking that 16600 and saying that since that is applicable, then we didn't do anything wrong. There's nothing wrong with the breach of contract because the contract is void. So if the contract is void, we obviously cannot break it. Void. Let's see. We got a comment. Oh my gosh. Guys, didn't we just talk about this? Oh my goodness. We literally just had this conversation. I told you it happens every single video. Yes, Miss LRGA, people are not slaves and slaves owners. They're not stolen. We agree. But there is what's called a contract. And your contract says that you won't solicit other people. And so you agree to that when you work for a company. It's much like when you get married, you have an agreement that you're not going to do things with other people outside of your marriage. So if your friend, say Eric Olson in this example, comes to your wife, says a bunch of lies about you, says he saw you out with Becky the other day and there's probably bad things that are happening, and then initiates a relationship with your wife, he didn't steal her, she's not a slave, but he broke her trust and he broke your trust. And he did it in a manner of lying about you to get his in. And that's exactly what's happened here. It's not that people are slaves. It's not that they're stuck where they're supposed to be, which is weird because like when you guys talk about people following Levitan over to Vantage, they're not slaves. They're allowed to go. But the difference is Olson waited out his 2 years and then he's outside of his contract and he can do whatever he wants. Did I say Levitan? I meant Levitan. I don't know if I said Olson there. Olson did not wait for his contract to expire. In fact, he was using the anchor leg strategy. So he was still with WFG, moving people to GFI under false pretenses. He was sleeping with somebody's wife under false pretenses, lying about the individual. So very, very different circumstances. I don't know how many times I have to say it. We literally talked about it this morning in hopes that I would not get any more of those comments, and it still happens. See, guys, I told you, every single time. So anyway, previously, the plaintiff filed a plea, a legally or claim breach of contract, found that 2.15, the non-solicitation ruling in Edwards. So again, they're just going to go back and reiterate all of those things. So the 16600 makes everything void. Wow, did I spell void there? V-O-I-D. Everything is void because of the 16600. I don't know what I wrote there. Wow, that was a, yeah. Anyway, so since all of those are void, you cannot then say that we broke our contract because the contract is not valid. You cannot break restrictive covenants then also because there is no contract, which also means, and this is all just more case law, you can't apply that because it's not valid, which means you also can't apply this because it's not valid. And it also means that you cannot apply this because it's also not valid. So we should just get rid of all of this stuff because it's all not valid. Restrictive covenant, it's a restrictive covenant which is not valid. So it means that it cannot be enforced. Which also means there cannot be any tortious interference because you can't harm somebody without breaking their contract, and since they didn't break the contract, they didn't do anything wrong. You also can't have civil conspiracy because if you don't break the contract, you can't work with multiple people to not break your contract, right? That would just be normal acts of daily living. You also can't have fraud because the contract is void. And so since all of that's void, there is no cause of action. They didn't do anything wrong. So if this is the way we're going to go, unfair competition, again, they didn't do anything wrong, so there's no cause of action. And there's no unjust enrichment because they didn't do anything wrong. They were just doing their normal business. And so again, there's no cause of action. So again, that should be void. So judge, in conclusion, please allow us to do whatever we want to do because 16600 says that we should, and we like that one, and we want you to have it apply that we can do whatever we want to do whenever we want to do it. We don't care if we destroy the entire industry. We don't care if we destroy our own company. We don't care if we destroy our former company. As long as you allow us to do what we want to do, then we'll be happy. We'll deal with the rest later. We'll go after a former president now because it suits our wants and needs now. And we'll worry about all the laws that we bent and we changed and all the illegal things that we did to try to make him look like he was guilty. We'll negate all of that stuff because it fits what we want today. We don't care about what happens into the future and how this gets applied against us later. None of it really matters. So anyway, Judge, please drop all of this stuff. Please dismiss without allowing them to even amend it. We appreciate you. Thank you, Judge. Please find in our favor, and we'll see you later. So anyway, that's basically par for the course, what we're used to seeing. So we'll see how that goes. We haven't had any updates on whether it's actually going to go to arbitration or what they're going to do from here. Olson's don't want it to go to arbitration because it's hard to get damages from it, and so they want it to stay in the courts. So we'll see how that goes. I appreciate you guys. Don't forget to also check out On Locals. If you want, you can see everything that's over there. You can get all the court documents and all of that stuff over there as well. Hope you guys have a fantastic weekend. I hope you have a ton of fun. Pray for us as we have our pickleball tournament on Sunday. We'll see how we do. It's our first men's doubles, so we'll see how that goes. Should be a ton of fun. But appreciate you guys. Hope you have a great weekend. Hope everything's going well in your world, and I will catch y'all later. Bye. Yep.